Appeals. We have two cases to be submitted today on oral argument, beginning with United States versus Kimble. Mr. Hennies.
Thank you, Judge Smith. May it please the court. In Diaz, this court made clear that prohibiting someone from exercising their Second Amendment right to keep and bear arms merely because they have been convicted of a crime that is classified as a felony today does not meet the historical rigor required by Rahimi and Bruin. Instead, Diaz found that history supports a narrower tradition, disarming individuals whose underlying convictions would have been subject to capital punishment or permanent estate forfeiture at the founding. And this court left the door open for as-applied challenges to 922G1 by individuals whose underlying convictions would not have been severely punished at the founding. Here, the government has failed to meet its heavy burden of showing a long-standing tradition of disarming someone like Kimble, who has prior convictions for drug distribution.
Is it unfair to infer that he could be deemed an inherently dangerous person given his prior convictions, both state and federal?
Absolutely not. So there's a couple of issues with that. We reject the idea that dangerous is the threshold for these kind of analyses. In Rahimi, the Supreme Court rejected the dangerousness argument. The government spent a lot of time saying that Congress can disarm anyone who is irresponsible, and they made very clear, both in their brief and at oral argument, that irresponsible just meant dangerous. And the Supreme Court rejected that argument.
When you say that, you mean they rejected the analysis that this particular person may be dangerous, and so therefore this particular person can be disarmed?
They rejected the idea that there is a Second Amendment test that hinges on dangerous.
But, well, I'm not, that may be a little bit overbroad because, I mean, Rahimi was about the civil domestic violence restraining order, and there was obviously a nexus between danger to someone who's subject to such an order and the disarmament, right? That was important.
It was important that he posed a credible threat.
The court found that he posed a threat of danger. So danger's got to factor into it somewhere, right?
If there's a credible threat of violence, I mean, I think one of the difficulties with danger is that it is it's a pretty vague term, and it's not clear what exactly that entails.
Well, I think it has to be linked to the predicate offense, right?
It would, but again, I think dangerousness is a one-way street to means-end scrutiny, to legislative or deference to the legislature. I mean, here, the government, in order to show that Mr. Kimble was purportedly dangerous, points to statistics today. So, that statistics is the ultimate look. We think that we have enough evidence to show that he is dangerous. That might be a good policy argument, but that doesn't meet the government's burden of showing a historical tradition.
But shouldn't we focus on the crime? I mean, the crime here is drug trafficking, right?
Correct.
I mean, isn't it fair to say there is a significant nexus between drug trafficking and violence?
Drug trafficking can lead to violence in certain cases. It certainly did not here. There's no evidence that Mr. Kimble's convictions, involved violence, misusing a firearm, or that he was even armed when he committed them.
So I'm just trying to think about how courts are going to deal with this, because a major theme in all of the Second Amendment litigation is how are courts supposed to apply it, the test, Bruin. And so if you have one drug trafficker whose drug trafficking offense showed some nexus to violence, but another person convicted of exactly the same crime, but just there's no nexus to violence in that person's offense, then you can disarm one person but not the other?
So this court hasn't quite weighed in on whether this is a categorical approach or not, but I think just to take a little bit of a step back and to maybe state the obvious, if someone commits the crime of drug trafficking and they also use violence, they can be prosecuted and convicted for that violent crime. And then under this court's precedent in Schnur and Bullock, that underlying crime can result in lifetime disarmament under 922G1. So we're not saying, if there is violence involved in the drug trafficking, the government is free to prosecute that, and a conviction would lead ultimately to 922G1 prohibiting that person from possessing firearms. But in this case, Schnur kind of suggests that maybe the categorical approach, crime of violence, elements-based test applies in this situation. And certainly, drug trafficking doesn't fall as a crime of violence under that definition. There's no use of force that's required.
Oh, wait a second. The crime of violence stuff from like that other line of cases?
Yeah, ACCA, et cetera, et cetera.
You want us to import that into this?
It's been much maligned. But
I would consider resigning from the bench if we did that.
It's been much maligned, but, the Supreme Court has said there are good reasons for this. And one of them is this, there's very little incentive for a defendant to contest irrelevant facts. And, it's relitigating those kind of things. And I think that is why it's important, as I said just a minute ago, that if a drug trafficking crime leads to violence, the government can prosecute that violent crime. And again, under Schnur and Bullock, that person is violent, so that person can be disarmed under.
Again, when you say that, I'm looking at the specific defendant here and looking at the characteristics of his crime. Is that right?
Again, I don't think this court hasn't really.
I know.
But I think in this case it doesn't matter, because if you adopt the categorical approach, drug trafficking is not a crime of violence. And if you look at the specific characteristics of how Mr. Kimble committed his crimes, he wasn't even armed. There's no threat of violence. These are just marketplace transactions for a controlled substance. So under either the categorical or a more, nuanced looking at the underlying conduct analysis, this isn't a violent crime or doesn't involve any kind of threat of violence. So just on the dangerousness, I want to, Reese also says that the government there raised the same special danger of misusing firearms. Reese said we don't have that kind of high level of generality. That's doing what Justice Barrett and Rahimi warned against, finding these things at such a high level of generality that it waters down the right. And this court in Connolly exhaustively analyzed the exact same evidence the government presents here for its special danger argument and said not one piece of evidence suggests that Congress can disarm anyone it deems dangerous. It is limited to political traitors, potential insurrectionists, neither one of which include someone convicted of a drug trafficking crime. I want to go to the government's other tradition. They try to fit this case under Diaz and the tradition of permanent punishment, but that effort stretches analogical reasoning to its breaking point. The government can't cite an analogous felony that was specifically targeting the same conduct at the founding.
Well, the government says what? Trafficking in illicit goods? Is that right?
I don't even think any of their predicates involve trafficking. The only one that is remotely close is receiving a stolen horse.
Okay.
And that makes it very clear that you can't receive a stolen horse if you know it was stolen because you're an accessory to the underlying crime. It's not any kind of a trafficking offense. And I think, in Connolly, this court said analogical reasoning requires sound judgment. It requires common sense. So comparing horse theft to vehicle theft in Diaz, that makes sense. That is a pretty straightforward analysis. But when you start comparing receiving a stolen horse to distributing controlled substances, that strains analogical reasoning beyond what can possibly, work. And this court has rejected analogs that are a tighter fit. In Connolly, it rejected intoxicated carry laws, mentally ill laws as applied to somebody who's a drug user. In Reese, there's all these laws about, parents having to provide guns to children and universities banning firearms, and this court said it wasn't analogous to prohibiting 18 to 21-year-olds. And I think it's also important to look at the purposes that the government's analogs were passed for. These are theft or fraud crimes. They were passed to protect property rights. They were passed to ensure the United States Postal Service was effective in its very, very young days. They were passed to ensure the integrity of U.S. securities, whereas controlled substances are just completely different. They're passed to protect public health, to avoid, a public health issue. So not only do the laws, they prohibit very different conduct, but they are also passed for very different purposes and very different reasons. And I think, maybe if the government had come forward and said, say, here's some smuggling laws from the founding that were punished by death or permanent estate forfeiture, that could work because, there were certainly customs and duties that were imposed at the founding. And if the government, in Connolly, this court said the closest comparator to drugs was alcohol at the founding. So if the government had come forward with some moonshining or bootlegging laws that were punished by capital punishment or estate forfeiture, that might have worked. But here, these laws that they have cited are not remotely similar to possessing a controlled substance. That is really all I have to say. There's two traditions the government has: the permanent punishment, that doesn't work; the dangerousness theory, that doesn't work. So this court should hold that 922G1 violates the Second Amendment as applied to Kimble.
All right.
Thank you.
You've saved time for rebuttal, Mr. Hennies. Thank you. Ms. Bradley?
May it please the court, Lauren Tanner Bradley for the United States. Two aspects of this country's historical traditions support disarming convicted drug traffickers like Mr. Kimble. We just heard a lot about these. The first tradition this court recognized in Diaz was that our country severely and permanently punished serious crimes, including but not limited to those crimes that were punished capitally at the founding. The second tradition has been recognized by the Supreme Court and this court, and that is that we have a tradition of disarming those who pose a threat to the safety of others, including with the misuse of firearms. We take these two traditions together, and those taken together support disarming Kimble here too. And I do want to point out that every circuit to address this issue has said that drug traffickers can be constitutionally disarmed under 922G3 or G1, consistent with our historical tradition. And this court should hold the same.
Is their rationale consistent, the other circuits?
The other circuits have anchored their analysis in a dangerous assessment.
You might want to move the microphone down.
The other courts have, the Third and the Sixth Circuit have, and the Eighth Circuit too, have anchored their analysis in a dangerousness analysis, saying that these are individuals who pose a serious risk to public safety. This court has also taken a different approach by anchoring its analysis both in danger along the Bullock line of cases, but also along the Diaz case, which is that we have a tradition of historically, severely, and permanently punishing individuals.
So that's why I asked, because Third and Sixth, as you just said, it seems to me it's possible that what they're looking at is the dangerousness of this individual and his history of interactions with with guns. Is that what they're looking at? Because that's different from what we do. We're trying to find some kind of historical analog crime that has been traditionally punished.
I don't think it's entirely different from what this court is doing. I think that this court has recognized two broad traditions that support disarmament. But in terms of the Diaz analysis, we are looking at we are looking at the predicate felony conviction, right. And if we can tether it to some kind of historical tradition, but we are not looking. This is not a hunt for historical matches. We are not.
That's certainly true. I read Rahimi. So what's your argument on that? What are the best historical analogs that are not twins to drug trafficking that would guide us in this case? So
in our history, death and estate forfeiture were ubiquitous at the founding, and they attended many crimes, all kinds of varieties of crimes, including illegal trafficking.
Yeah, but you're not, let me just make sure that the government is not arguing this. You're not saying that any crime that could have been punished by death or estate forfeiture could today be a predicate for disarmament under the Second Amendment. You're not saying that, are you?
It is the government's position that the characterization of a crime as a felony is sufficient, but we understand that this court has rejected that analysis.
Right. I mean, so I just want to understand where the United States is coming from on this. Are you saying that, for example, the forgery of a security device, a bill of lading, that would have been a forgery of those kinds of instruments, probably would have been punishable by death, right?
It is our position that felony is sufficient, and we understand
alone.
rejected. We understand this has been rejected by this court. And
Okay, so for example, I mean, remember the Gibson guitar case where there was the guitar maker was prosecuted for smuggling in ebony wood from Madagascar? That was a big case. It was prosecuted under the Lacey Act. Could that person be disarmed?
I think that I understand what this court is.
Because that has nothing to do with violence or danger.
And so allow me to, again, our position is what it is. We understand that this court has foreclosed this position.
I just want to understand.
And we understand that there are some unique applications of 922G1, and the administration is actually taking part in a process attempting to reestablish some administrative procedures because we understand that the courts have expressed some concern about certain applications. And through reestablishing the administrative scheme under 925C, that maybe some of these concerns could be alleviated to provide some kind of individualized determination as to dangerousness and whether someone could have their disability restored and within the confines of public safety.
So, but back to my original question, what are the historical analogs?
So the historical analogs are involving illegal trafficking. And so we actually do see in the history that smuggling was capitally punished at the founding. And you can see that in the Blackstone commentaries that are cited throughout the case law and in our briefing. There also a commodity that was the trade of tobacco, a highly regulated commodity. This was something where smuggling tobacco was capitally punished at the founding, and it was also technical violations of how tobacco was traded. Things like if you alter the tobacco after it's been inspected, if you traffic in tobacco that has a fraudulent inspection stamp, if you use counterfeit stamps. And you know this is happening and you're receiving and trading in tobacco.
But merely because the government says, as a federal matter, this is illicit, the tobacco trade or the smuggling of whatever, doesn't matter what it is, you can be disarmed for that.
At the founding, our founding fathers were capitally punishing all manner of crimes. And we may disagree with some of those policy choices. Policy decisions do change over time. The Rahimi analysis does not relegate us to the policy choices of our founding fathers.
Yeah, but Rahimi looked for analogs to the domestic violence restraining order, and they looked at, the whatever the laws were called, the open, the terrorizing, carrying weapons in such a way that makes other people afraid, that sort of thing. You're saying the analog here is just smuggling.
Yes, the analog here, the best analog is smuggling. There's also, like Mr. Kimble pointed out, receipt of a stolen horse, that we were punishing all manner of crimes of smuggling tobacco, of receiving stolen goods, so not just the act of theft, but the receipt of these and the trade of these goods, and also of trading in counterfeits. And
so my Gibson guitar example then is a yes, right? If you are illegally importing Madagascar ebony wood to make guitars, it's a crime under the Lacey Act. Then you can be disarmed if you do that?
Yes, that is the government's position, but I will also point out that this court does not have to address those more those closer applications, right? This court is presented today with drug trafficking, which we all agree is a very dangerous crime with a high propensity for violence. And so what we're actually talking...
That's a much narrower ground for ruling in your favor, though, right?
Well...
linking the drug trafficking to violence to...
Yes, but I want to be clear that this is not a separate argument that we're posing. Rahimi instructs us to take these principles together and combine them, and we look at them together to determine if this is a law that is relevantly similar to what laws our historical tradition was understood to permit. And so we're really combining these two things, that we have drug trafficking, which is similar to those activities that were punished harshly at the founding, and then also this crime that is highly dangerous and has a real propensity to erupt into violence, especially when firearms are combined. And it's really an intersection of these two traditions, and it makes the analogical reasoning makes sense, but also it is sound judgment, and we are instructed to apply sound judgment here.
Apply sound judgment in all of our cases, though. I just don't understand that as a separate test. Sound judgment. Well, okay. I'll be sure to do that.
I am just adhering
I know,
to what
I
the
know,
Supreme
I
Court
know.
has told us to do in Rahimi.
We tried to.
But I do want to point out that there are other analogs too, right? We have burglary and robbery and theft, and these may not look like trafficking, right? But again, we are not matching up historical crimes to modern day crimes. We're looking at the underlying principles, and we are considering the why and the how. And Diaz provides the why. Okay, Diaz provided a broad why. It said that the point of this, that these laws were purposed to deter violence and lawlessness, that's at 469, and to protect the public safety. And we see that same reasoning being applied in the Schnur case. And all of these laws together, the point is to deter violence and lawlessness. And that fits within our historical tradition. So looking at this historical evidence as a whole, disarming Kimble, who, like counterfeiters and smugglers of the past, repeatedly possessed and trafficked in illegal goods. And that fits neatly within our historical tradition of severe and permanent punishment, and also within our tradition of disarming those who pose a grave danger to the public safety. I want to talk about how.
Are you asking us to rule that all drug trafficking sort of is per se dangerous with respect to the Second Amendment? In other words, anybody, regardless of the circumstances of the particular crime, all drug trafficking?
This court does not have to reach such a broad ruling, but
How do we cut it down then?
I mean, I believe it is strongly supported by the historical evidence here in the Third, Sixth, and Eighth Circuits. Well, the Eighth Circuit they have said just as a matter of course that felony by felony litigation is not necessary. But the Third and Sixth Circuit in Williams and White have said that drug trafficking is particularly dangerous and is per se, you can be constitutionally disarmed for this purpose.
I mean, that's not, I'll be honest, that's not a crazy argument. I just want to understand what the government
I would
is.
argue it's sound judgment, yes.
It was, yes. Well, it's all sound judgment.
Yes.
But so the government's view, it sounds like to me the government's view is drug trafficking can per se be a predicate for disarmament.
Yes, absolutely. And that goes again to this point of, I think that what Kimble is asking this court to do is to really narrow down the principles and to identify a twin to match these historical crimes, and that is not what this court is tasked with doing. And you can look to Diaz and you can look to the bulk line of cases to look for these more broad principles that we're supposed to be applying. I also do want to, I do think it's important to point out that Rahimi did not in any way reject a dangerousness analysis, that this court has already recognized this. There is an undeniable through line in our history that we took guns away from people who were deemed to be dangerous. And I think that we cannot place an undue weight on the failure to regulate at the founding because societal perceptions may change.
You mean, I think that argument is, you're saying, well, they weren't concerned with drug trafficking or the trafficking, say, of alcohol or substances per se. At the founding, that has become a problem, but that doesn't prevent us from disarming merely because it wasn't seen as a problem.
Yes, 100%. That our societal perceptions of the problems have changed in the same way that we were, severely and permanently punishing theft at the founding, that seemed to be the policy choice du jour. But today, the policy choices have changed. And the Bruin analysis allows for that evolution, right? We are tethering something to history, but we are not binding ourselves to a law trapped in amber. If there are no further questions, we would ask that this court affirm because disarming convicted drug traffickers, a repeated drug trafficker like Mr. Kimble, fits neatly within our tradition of severely and permanently punishing serious crimes, including those involving trafficking, and he does pose an inherent risk to of violence and public safety. Thank you.
Thank you, Ms. Bradley. Mr. Hennies for a rebuttal.
I want to start with Judge Duncan's question about the other circuits. the Third Circuit, the Sixth Circuit, and the Eighth Circuit are flatly inconsistent with the analysis this court applies in the Second Amendment context.
Also.
Those courts analyzed the same evidence that Connolly analyzed, and honestly that the government has cited in Rahimi merits briefing, here in Connolly, starting from England and working all the way up. And this court said, not one piece of historical evidence supports the idea that Congress could disarm anyone it deems dangerous. It was more targeted. Those were targeted at political insurrectionists and those kind of things. The Eighth Circuit and the Sixth Circuit have said that evidence supports a broad tradition of disarming anyone that Congress deems dangerous. So it's in direct conflict. And I also want to correct one misstatement. The Sixth Circuit Counsel said was a per se rule that drug trafficking can be disarmed, and that isn't quite what the Sixth Circuit said. The Sixth Circuit said it's going to be a fact-intensive, fact-specific analysis to determine whether somebody is dangerous. Again, dangerous we don't believe that's a test, but even under a fact-specific analysis of Kimble's offenses here, there's just simply no evidence that he poses any danger. He didn't even have a gun. These were deals they were illegal substances, but there was no violence involved. The government proposes a kind of a new test, I think. It says
he didn't have a gun when he committed his drug offenses.
Right. There's no evidence that he even possessed a gun.
He had a gun when he got convicted of being a felon in possession of a gun.
Right, of course. But he wasn't trafficking drugs at that time.
I mean, you kind of try to make it sound like he never had a gun.
I'm saying his underlying convictions, the government is making drug trafficking out to be very dangerous, but in Kimble's case, that simply wasn't the case. He possessed a gun when he got arrested for this offense.
Sure, drug traffickers are hoping it's not very dangerous, but the guns mean they're probably prepared for it to get dangerous.
It might, but again, in Mr. Kimble's case, he did not have a gun. There's no evidence of that. So, I think Diaz tells us that we have to look at, the prior convictions. We don't look at your concurrent conduct at the time you possessed a gun.
You don't dispute that he's a drug trafficker, that he was convicted.
No, absolutely not.
Drug trafficker.
Absolutely not.
All right.
The government kind of, proposes a new test about propensity for violence. I don't know how to apply that in the context of history. I don't know what propensity for violence, I don't know what threshold that is looking at. That looks like just defer to whatever the Congress says is, potentially violent. And Rahimi says the exact opposite. It says, our nation's tradition of firearm regulation distinguishes citizens who have been found to pose a credible threat to the physical safety of others from those who have not. And there's no indication here that Kimble posed a credible threat to others. The theft and burglary that the government cites now, those aren't remotely similar. Those involve taking property from another against their will. Drug distribution involves selling it to a willing buyer. Granted, obviously it's an illegal thing. And I just want to go back to this Rahimi and dangerousness. And what did Rahimi say about that? And I think it's telling here that if you look at the government's brief, in this case, footnotes 2 through 7 and 10 through 13, those footnotes cite 76 different sources for their special danger theory. And those footnotes are all copy and pasted directly from the government's merits brief in Rahimi. And that is a argument, to be clear, the Supreme Court unanimously rejected. And I think Justice Thomas, who agreed with the majority on this point, says that it doesn't matter how many adjectives you swap out. This is not a theory that is moored in history, tradition, or the Constitution. And again, this is an as-applied challenge. There is simply no evidence that Kimble himself has a propensity for violence. So this court should hold that 922G1 violates the Second Amendment as applied to him. Thank you.
Thank you.
Thank you, Mr. Hennies. Your case is under submission. Remaining case for